Thank you, Mr. Speaker. It's been a great privilege to be able to sit through this debate with an extraordinary number of honourable, right honourable and learned members, many of whom with very direct experience, both as lawyers in the claimant industry and also with connections to the insurance industry. It's been a very well-informed debate. Essentially, these proposals that we're bringing forward in this piece of legislation are serious proposals, but they are, to some extent, Mr. Speaker, matters of housekeeping. They follow a very lengthy and extensive consultation over a number of years, and they attempt essentially to do three things. The first is to try to improve the administration of justice in certain key but relatively limited ways. Secondly, to address some issues around public morality and honesty. And thirdly, to make sure that we guard resources, whether of the interests of people who are paying for their motor premiums or thinking about the interests of people who are supporting the NHS. A number of objections have been made by honourable and right honourable members across the chamber, and in particular 7 of them have stood out. 4 of those I would respectfully and politely disagree with. 3 of those have, I think, some real heft to them, and we will take into account in the way that we proceed with this bill. The first of those objections has largely focused from the honourable members of Ashfield and Jarrow on the questions of damage in the workplace and to people with non-whiplash related injuries. This is not strictly relevant to this bill, which deals with whiplash related injuries. The change in terms of non-whiplash related injuries is proposed to be a change from £1,000 to £2,000, roughly in line with RPI since it was set in 1991, and dealing with roughly the same category of cases that were intended when the legislation was first introduced in 1991. The second issue that's been raised is that some honourable members have suggested that there is no evidence. This, of course, would be somewhat depressing to the people who conducted an extremely extensive consultation, which has taken evidence not simply from the insurance industry as been suggested, but from the DWP, from claimant lawyers, from the MRO, and from a very large public consultation. The honourable members of Jarrow and to some extent Enfield Southgate and Cardiff Central suggested there were in fact very few fraudulent whiplash claims made. Now, again, this is an issue which, as the honourable member for Croydon South pointed out quite eloquently, is a difficult issue to pursue because of the asymmetry of information. In other words, quite frankly, as the honourable member for Croydon South points out, it is extremely difficult to prove whether or not somebody has a whiplash claim. By its very nature, it's a concealed injury. Nevertheless, and I'll come on to this later, the statistics, in particular those raised by the honourable members for Spelthorne, showing that the number of traffic accidents has reduced by a third, while the number of claims has gone up by 40%, while at the same time, as the honourable member for Walsall North has pointed out, cars have got considerably safer, suggests something is going on in relation to these claims. The fourth objection made by the honourable member for Lewisham West and Penge was about the issue of access to justice, Mr. Speaker. The suggestion then is that it's inappropriate to suggest that people should proceed to a small claims court for claims of under £5,000. Now, the vast majority of these existing claims, do not proceed to court at all, and the district judges ruling on these claims are used to dealing with claims up to £10,000. The 3 more serious objections made we are, however, addressing. One of them, Mr. Speaker, is the idea that the insurance industry will not pass on the savings in the forms of premium savings to motorists. We will therefore, as the Secretary of State has indicated, be introducing an amendment which will be shortly with the House and which will be available for committee and report stage, addressing this exact concern from the honourable members of Harrow West, Leeds East, Jarrow and South Leicestershire, and indeed the honourable members for Hammersmith, High Peak and Jarrow. The second serious concern was about vulnerable road users, raised by the honourable members for Chelmsford, Cambridge, Brentford and Isleworth. There too we will be introducing changes to ensure that vulnerable road users are excluded from the scope of both of the bills and the raise in the limit. The Honourable Member for Croydon South and some others raised concerns around PPOs, and again there, Secretary of State has written to the Master of Rolls to ensure that periodic payment orders are introduced more frequently in order to ensure that particularly vulnerable people suffering problems around lifetime care costs are genuinely able to get regular, sustainable, reliable payments out of the insurance industry to sustain them.
Would the Minister give way?
Very briefly, because I've been told to stop in 3 minutes.
What does the Minister think of the idea that we might tweak the system so periodic payment orders become the default setting, the automatic setting, unless a judge agrees there's a good reason to do otherwise and make a lump sum payment?
Very, very happy to take this issue offline with the Honourable Member for Croydon South, but there's a lot to be said for PPAs. In essence, Mr. Speaker, driving towards a conclusion, there are 3 fundamental arguments that we would make in favour of this bill. The first is that we need to ensure that the administration of justice is proportionate and sustainable. And as the Honourable Member for Chelmsford pointed out, there are serious issues about nearly 40% of the costs currently being absorbed by legal fees. Secondly, we need to make sure that it's straightforward, and as the Honourable Member for North West Warwickshire has pointed out, the introduction of the portal will make sure the administration is more straightforward. As the Honourable Member for Croydon South also points out, the introduction of fixed tariffs on the French model will make the administration of justice more predictable. The question of fraud and morality is also at the centre of these changes. As the Honourable Member of Bromley and Chislehurst pointed out, fraud does happen. As the Honourable Member for South Norfolk pointed out, this can often be extremely flagrant. As the Honourable Members for Spelsthorne and Walsall North pointed out, it is at least the case, if we cannot prove every case of fraud, that claims are becoming exaggerated. And indeed, as the Honourable Member of Walsall North pointed out, this can have medical consequences. In the polite words, Mr. Speaker, of the New England Journal for Medicine, elimination of compensation for pain and suffering is associated with a decreased incidence and an improved prognosis for whiplash injury. Right? This is the point made by the Honourable Member for Walsall North from Greece. But the fundamental point here is that we have a responsibility as a government to balance the administration of justice and honesty with the broader social costs. Insurance premiums, as the Right Honourable Member for Chipping Barnet has pointed out, have been rising, and we need to take them into account, particularly, as the Honourable Member for South Norfolk pointed out, and the Honourable Member for Bexhill and Battle, in rural areas. And again, as the Honourable Member for North Warwickshire points out, the cost of over £1 billion to the NHS, which will be addressed through this legislation, is a cost that is borne by every taxpayer and is causing increasing concern amongst medical professionals. Which is why, Mr. Speaker, this is a serious piece of legislation, but it addresses various focused points. It comes at the end of a very extensive consultation where we have made a number of concessions to address the concerns expressed across the House. During the House of Lords stage in particular, we have introduced new definitions on whiplash. We've involved the Chief Justice in the process. We've adjusted some of the timings on the discount rate. Through this legislation, we believe that we can make a contribution towards a more honest system, a system that is more proportional, a system that takes into account the significant social costs of exaggerated claims, and through a more simple, predictable, effective and rapid administration of justice, protects a range of social and economic interests while balancing the rights of road users, the rights of claimants, the rights of defendants, and ultimately the rights of citizens as taxpayers. Thank you very much, Mr. Speaker.
Thank you. Order. The question is that the bill be now read a second time. As many as have their opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The programme motion to be moved formally.
I beg to move.
Thank you. The question is the programme motion as on the order paper. As many as have their opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The money resolution to be moved formally.
I beg to move.
Thank you. The question is as on the order paper. As many as have their opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. Order. We come now to the adjournment. The whip to move.